Hello, my name is Benjamin Hart. I'm an American attorney and the Managing Director of Integrity Legal here in Bangkok, Thailand. This video today we're going to be discussing, well, exactly what the title says, third country nationals on Amity Treaty companies. What is an Amity Treaty company? Well, there are a number of videos on this channel where we discuss Amity Treaty companies specifically, and we get into rather great detail, especially with respect to certain tax obligations and other things like that. But the thing to take away from this video are for those nationals of countries that aren't the United States or Thailand, I often get questions of, well, what if we have an American primary shareholder and we want, to have, say, Swedish directors or a Swedish minority shareholder? Can we utilize the Amity Treaty? The short answer to this is no. Pursuant to the provisions of the Amity Treaty, it is by definition a bilateral relationship between the United States of America and the Kingdom of Thailand, and under the provisions of the agreement, only Americans or Thais are governed by it. So the results of this, in Thailand, an Amity Treaty certified company is going to be granted what's called national treatment under Thai law. So that company will be treated as if it's a Thai majority-owned company. And the nice thing about this is it can circumvent certain aspects of the Foreign Business Act here in the Kingdom. That being stated, there are certain circumstances where you might see, especially a large multinational corporation, want to bring in a third country national to act as something like a director. Pursuant to the provisions of the treaty specifically, this is not going to be possible. Only Thai nationals and United States citizens are allowed to be on are allowed to operate on treaty companies. Those companies that are operating outside of the scope of the treaty or in contravention of the provisions of the treaty would then probably, I think it's fairly safe to say, would be considered in violation of the Foreign Business Act, and that could be problematic for a number of reasons. So the thing to take away from this video is Amity Treaty companies can only have Thai and or American shareholders on them and directors. That being stated, third country nationals could in theory work for an Amity Treaty company. They simply cannot be principals in the sense that they cannot act as directors or shareholders of the company concerned.